least we'll give her that credit. I don't think anybody else is here from Ottawa, so we can say that. Preeminent lawyer in employment law in the Ottawa area. As you can see from her CV, she's involved with a number of important public organizations and a graduate of Call to the Bar in '76, graduate of University of Law of Ottawa, and a member of the director of the Advocacy Society from '98 to 2001. It's a great pleasure I introduce her, and hopefully, Janice, people will be filtering in, so.
Okay, no, that's not a problem. Thank you, Barry. I'm going to start taking that year of call out of there. It's probably enough gray hair that I don't need it anymore. Good afternoon, everybody. Thanks to those of you who ate fast and came back. I appreciate that. Let me start my remarks about my paper with a bit of an illustration. Assume you've got a case involving a senior employee, an executive perhaps, a shareholder as well, who's been terminated after a history of difficulties relating to both his terms and conditions of employment and perhaps his shareholdings as well. You're acting for either side in this scenario. The proposed severance package is either non-existent or inadequate. And the departing employee has decided to join another firm and go into competition with his former employer. The employer's concerned because it thinks that he's taken proprietary information with him. From the employee's point of view, his future remuneration remains uncertain. It's clear he's going to have some losses and that he certainly will not earn at the level he did prior to his dismissal. And maybe just to add a little more to the story, maybe the former employer is already starting to move assets outside of the jurisdiction. What do you do, whatever side of the file you're on, with facts like these? And you're right to think the traditional remedies, just starting the ordinary lawsuit looking for damages, is just not going to meet your client's needs, whether you're on the employer's side of the table or the employee's. What we tried to do in this paper was discuss different approaches that might address a scenario like that, and we've called them proactive remedies as opposed to what we've described as the usual reactive remedy. Remedies that we think could prove to be of better use to you and your clients than the traditional claims for damages. And I've found over the course of my practice that often the pursuit of a novel proactive remedy can precipitate a resolution of cases that could have languished otherwise for years in the legal system. If I have time at the end, I also jotted down some points, although I probably won't have time, but if I do, I'll talk about some proactive strategies that I like to use as well, short of actual legal claims. The remedies I'm going to cover quickly, and they're in the paper for the most part, are from the point of view of the employer, a motion for an Anton Pillar order, injunctive relief for prohibition against competition or solicitation, and from the point of view of the employee, remembering to pursue claims for reinstatement when they're available, claims for oppressive remedies, which might be particularly suitable in the scenario described at the beginning, a little bit on the latest on harassment remedies, and then one case involving claims for interim payment of wages pending litigation. Let me start by dealing with the Anton Pillar situation first of all. An employer may want to consider this when it suspects that an employee, whether he's been fired or is just left on his own, has taken trade secrets, customer lists, industrial designs, other property belonging to the employer with him or her. In a case like that, an employer could apply to the court for an Anton Pillar order to search the employee's house, vehicle, place of residence to obtain copies of material, perhaps even retrieve material. There's an early case described in the paper called Bardo and Crown Food Service Equipment, where a former employer did exactly this. This is back in the 80s, 1982 case. The employer there was a large manufacturer, distributor of metal food industry equipment, and the president himself owned several designs. The relationship with a couple of his employees failed. actually more than two, a few of them left and set up in competition against him and seemed to be moving awfully quickly for people who would have to start designing their own equipment all over again. So he was suspicious that they had property belonging to him and were misusing it. In that case, he successfully sought an Anton Piller order, and it allowed him to search the business offices, residences, vehicles of the former employees and recover copies of material that he said had been stolen. A more recent example of this, a sort of high-tech example, if you like, is in the paper as well, involving a successful use of an Anton Piller order. Showcase Limited and Alliance, Universal Showcase Limited and Alliance store fixtures. It's a 2002 case. There, the employer was involved in the manufacture of fixtures for use in retail businesses. And again, employees left, taking what the employer was sure was proprietary information, this time in their laptops. And what he wanted, and he applied for it, was both interim relief restraining them from competing, from soliciting clients, and also an order requiring them to produce their laptops for inspection. The court reviewed the situation and decided there wasn't enough to support the interim injunction restraining competition, but was satisfied that it was proper to make an order requiring the employees to produce their laptops for inspection. And this, even though the laptops were arguably owned by the employees. That was in some debate, but the court said it didn't matter. This is the only case I want to read a little bit from, but this is what Justice Nordheimer had to say. There's a reasonable basis, therefore, for the plaintiff to believe that information belonging to it may have been on these computers when the individual defendants resigned. The plaintiff is entitled to know whether its belief in this regard is correct or not. And the court went ahead and made the order. Reading again, the plaintiff is entitled to know what, if any, information belonging to it may be on these computers so that they can later make submissions regarding its confidentiality. It wasn't even completely clear that the information the employer was complaining about was confidential. The whole issue, the court said, is a matter that could be canvassed at the examinations for discovery, and I see no reason why it should not be addressed now. Now, I don't know whether any of you have run into this situation. I've certainly had opposing counsel say, I want to see your man's computer. I want to see what's on it. And this sort of thing threatened. I've not had it done, but I think it's something that we should all bear in mind, especially these days when so much of the information we have is indeed on our laptops. Another case in the paper, just a third example before I leave it, involved one a little closer to home. Estrada and L'Esperance involved a lawyer who suspected his assistant of undertaking services for clients from her home. And he applied for and got an order allowing him to search her home. In the end, the court looked at the information and was satisfied that there was no basis for the allegations. The plaintiff assistant succeeded in her claim for damages for wrongful dismissal and even recovered a Wallace Award because of the unfounded nature of the allegations. But the court was really careful in its review of what had gone on to say there was nothing the matter with the application for the order that was made by the employer in the first instance, that employers who have suspicions, who are concerned, should be encouraged to use the legal process, and they won't find themselves exposed to additional Wallace-type damages if they do. So the case we thought was interesting from that point of view. The other area I wanted to talk about from the employer's point of view is what we're all familiar with, applications for injunctions to prevent unlawful competition or solicitation of clients, customers, former colleagues. And these arise, as we know, in the context of both restrictive covenants in written contracts or in the context of alleged fiduciary duties that may be owed not to compete unfairly. Just remind us all of the usual three-pronged test to succeed on these things. There has to be a serious issue to be tried. The moving party has to establish that it will suffer irreparable harm without the interlocutory injunction, and that the balance of convenience favors the moving party. All I want to do quickly is talk about the three areas in which employment cases offer some unique features to other cases in the area of interlocutory injunctions. First of all, it does seem pretty clear that in the employment context, when the employer is complaining about competition from a former employee, that it will have to do more than show there's a serious issue to be tried. The courts in Ontario are pretty consistent that there's got to be a strong prima facie case, and have been clear that when you're challenging someone's ability to earn a livelihood, that's the test you've got to meet, a little higher than just a serious issue to be tried. Another feature in employment cases that we're starting to see, and it's frankly not clear to me what the prevailing view is, but some courts have said that the employer also carries an onus, if it's going to make out a strong prima facie case, that it's dealt with its employee lawfully. So, for example, as in the Teleshop case, which is talked about in the paper, if the employer has alleged cause for dismissal, has dismissed without notice or compensation, and is now seeking to enforce a non-competition obligation, whether under contract or otherwise, the court's going to want to be reasonably satisfied that there's a strong prima facie case for cause, or it will not be as inclined to grant the interlocutory relief. There's a couple of cases discussed in the paper along those lines, and I run into it frequently with clients who come in and say, I was treated so badly, how can they now rely on the contract? We might have time to talk about this more a little later. I don't think it's completely clear, but there is some case law that has said the employer better be in a position to show that it's behaved properly, or at least that there's a strong prima facie case. And when it comes to matters of irreparable injury, we've all seen the contracts that employer counsel are drafting now saying, look, I have these obligations, and if I breach them, we agree that the employer will suffer irreparable injury, and you can apply for and obtain an injunction. Justice Nordheimer, again, in a case called Jetprint that we refer to in the paper, has said probably that language isn't enough. The court will take an objective view of exactly what's going on, what the fact situation is, and make its own decision about that. There are cases that have indicated otherwise, though, and have held individuals to their contract. Before leaving injunctions, I also want to flag something for you that we had some experience with this year, which isn't in the paper, and that is if you're acting for a plaintiff and you see the assets disappearing on the other side, it may also be possible to obtain an order for preservation of those assets, and that's something to think about. And again, in the right case with the right facts, you may make some progress. We did have some of that this year in our office. Shifting now to what employees can do in a proactive way, let me come back to the notion of, first of all, reinstatement. Reinstatement can be available to employees. It's unusual, as we all know, but the paper identifies three areas. One, in the context of judicial review of the decision to dismiss, where that's available. And it's just always important to remember, especially if you're dealing with a public sector or statutory kind of situation, that it might be available. Secondly, Canada Labour Code. It's always important to those of us practicing in Ottawa, but there are federal employees in the Toronto area too. Remember that if you're under the Canada Labour Code, there may be a right or a claim to reinstatement. I'll say more about it in a minute. And then we have some commentary on a line of cases involving religious officers as well, which are interesting. Let me start with the judicial review very quickly. Where you start with that is you turn your mind to whether there are some statutory provisions that apply to the employment relationship in question. It can be relevant in the context of municipalities, the Municipal Act, boards of education, library boards, police boards, universities, and so on. Take a look at those statutory provisions. If you're acting for an employee, is your employee actually a statutory officer? Does he or she have a set of rights under the statute, and have they been honored? If they have not, there may be a basis for judicial review. But whether he or she is a statutory officer or not, if there's a statutory public flavor to what the individual is doing, there may well be a duty on the part of the employer to deal fairly with the individual, to show procedural fairness to the individual, and if that duty hasn't been followed, it may be possible to look for judicial review and reinstatement. With apologies to my colleague who was on that case with me. A few years ago, I had dealt with a case like that involving the city of Canada, now no longer, now part of the great city of Ottawa, where council had met in secret and decided to dismiss two senior people. One was the city engineer, who was, of course, a statutory officer. One was the director of human resources, who was not. Both were dismissed and given the packages they were entitled to under city bylaws. Because they'd been given no warning, because they'd been given no opportunity to address council, to address the concerns raised about them before council, the application for judicial review was successful in setting aside their dismissals. They were reinstated. Now, the city did it procedurally correctly a couple of months later, and at the end of the day, what we had, I suppose, arguably was just enhanced severance. But that provided some satisfaction to the people I was looking after, and at least they did have a chance to address council and attempt to address the concerns. So just something to remember. It behooves all of us to consider whether you've got the kind of individual that could claim a remedy like that. Ultimately, and I think an example where a proactive remedy did get things resolved, we were successful in resolving the thing fairly quickly after the second dismissal and getting things tidied up without further litigation. Canada Labour Code I mentioned a moment ago. That's the second example of reinstatement. It's under the unjust dismissal provisions in the code. You need to be dealing with an employer that works in a business that is federally regulated. And if you are, all of the non-unionized employees may, up to the level of low-level management, may be entitled to bring an unjust dismissal complaint if they're dismissed and seek reinstatement. Not applicable if what you've got is a reorganization or dismissal due to loss of work, discontinuance of a function. But if there's anything else, these individuals may be entitled to lay a complaint and seek and obtain reinstatement. There's a 90-day time limit for filing that complaint from the date of dismissal. And just quickly, the line of cases involving religious officers was interesting. The case mentioned in the paper is McCaw United Church of Canada. Plaintiff there was a minister of the United Church, and he was stricken from the rolls of the church, which meant he couldn't practice as a minister anymore. The Ontario Court of Appeal concluded that the decision to strike him from the rolls was contrary to the manual of the church, a bit like the procedural fairness cases, that he had not been dealt with properly in accordance with the manual of the church, and that the proper remedy was reinstatement. I've run into situations involving rabbis and others. It's something to think about, that the court won't necessarily simply move in these rather unusual situations and apply common law principles. Oppression remedies. If the employee is a shareholder and if the conduct of which the dismissal is a part is all part of some sort of oppressive course of action against the individual as a shareholder, you may be able to style your lawsuit under the Canada or Ontario Business Corporations Act and seek a whole host of very creative remedies for the individual. Some of these are discussed in the paper, but the courts generally have very broad powers under the oppression remedy, as most of us will remember from law school, to make any sort of order that is appropriate in the circumstances, including an order replacing directors, an order for compensation, an order requiring wind-up of the business, an order requiring the corporation to buy out the individual's interests. The reasonable expectations of the parties, though, will be critical to whether the oppression remedy is appropriate and just what sort of relief will be ordered. We pursued a case in the last year for a plaintiff seeking an oppression remedy, and were disappointed in the result because the court was not satisfied, even though the activities of the venture capital shareholders seemed to be oppressive of the minority. There wasn't much doubt about that. The expectation of the parties was that the venture capital shareholder could probably proceed in the way that it did, and so the court was not prepared to grant relief. So a neat remedy, but remember that it's got to be, what you're looking for has to be something that's within the reasonable expectations of the parties. And I won't say more about it other than the Nanef case, which is the leading case in the Ontario Court of Appeal, is discussed and provides a really interesting example of when you can use it. I said I'd give you some sense of the latest on harassment. We weren't able to find a lot on this, but there was, and it's good to remember it, a 1996 decision called Au and Lyndhurst Hospital involving a complaint for harassment made by the employee under the Occupational Health and Safety Act. She decided she was going to get a faster result that way than with litigation or a human rights complaint. And while she did not make out her case on the facts of her case, the board did conclude it had jurisdiction and in the right case would take jurisdiction. Interim payment of wages pending litigation. Case is discussed in the paper, Pablo and Wilson. Generally, the cases where this has been possible have involved contracts where there is a clear entitlement to ongoing salary continuance. But I think where you've got that entitlement, if there's any suggestion the employer is holding back because you've dared to sue for more, it may be interesting to contemplate bringing a motion for some interim relief for your employee client seeking ongoing salary continuance. 3 minutes, eh? Okay, that's so much then for the paper. I wanted to say something very quickly about my proactive strategies. Some of this Justice Echlin already touched on this morning, and I found his presentation as interesting as I'm sure all of you did. From a plaintiff's point of view, after the letters haven't worked, think about drafting the claim, drafting the human rights complaint, sending it off and saying, no, I really mean it. We weren't just bluffing. This is being issued in 48 hours unless we can sit down. Think about voluntary mediation before the lawsuit is started. I find it really effective on both sides of the table for resolving disputes early. If both sides agree to an early voluntary mediation, it's a good sign. There's probably some interest in resolving a problem before it gets too expensive. And I think that thinking applies whether you're on the plaintiff's side or the defendant's side. That's it. I think that's plenty on that paper. Thank you very much. We probably don't have time for questions, do we?
You can take questions. Sure.
If we've got anything quickly. David?
Just a quick comment. Janice, you won't remember this, but I remember it because it took a while for the scars to heal. Janice was representing an employee. I was representing an American software development company. And of course, like many American companies, they think Canada's just the 51st state anyway, and it has the same between jurisdictions. And so, of course, Americans start from the presumption of employment at will, and they fired Janice's client and really weren't interested in doing much to try to get Janice's client's wrongful dismissal claim resolved. And so Janice was as good as her word. She very politely said, look, we need to get this resolved. Sorry, I'm usually fairly mouthy and I don't need a mic. And if we can't come together, you're going to leave us with no alternative other than to file a human rights complaint. And of course, human rights legislation is legislation under which there is a statutory right of reinstatement. And so I took that to my client. My client said, let's see. So Janice did have the human rights complaint issued. It did start down the process. And it was, Janice, you'll remember, it was the human rights complaint that got my client and I to take the trip to Ottawa, where we finally did resolve the matter. So when Janice says that those things can provide some leverage, she's not kidding. A couple other things to keep in mind if you're in Quebec. There's Section 124 of the Quebec Labour Standards Act that provides a similar remedy to Section 240 of the Canada Labour Code, which is the unjust dismissal action, or the wrongful dismissal action. Also keep in mind that that labor relations legislation has reinstatement provisions, as obviously does human rights legislation.
Thanks, David.
And watch the pregnancy leave complaints. You can get reinstatement there.
Yeah, actually, thank you for that, because there are lots of more examples of statutory rights to reinstatement than we flagged in the paper. One more question, and then I better sit down. Anybody got anything else? Good. Okay,
Thank you very much. Well, I think that our next speaker, David Cote, has just introduced himself. So David is a senior partner at Baker McKenzie for the last number of years, and he's one of just a couple of people who, when I just want to run something off somebody, I call when I'm just not comfortable with precisely whether I'm thinking of absolutely the best approach to use. I find he's got very good common sense, judgment, and knowledge of the law. David has been profiled in a lot of news reports around the SARS crisis, and that inspired us to today's topic on how to deal with emergencies.
Thanks. You know, it's interesting. As I was preparing comments for the topic, I had either a momentary lapse in memory or a mental pause, which I hope isn't contagious, while trying to remember what SARS stands for. And of course, it stands for Severe Acute Respiratory Syndrome. But my momentary lapse in memory demonstrates how much the uncertainty and downright worry of last spring has perhaps faded from some of our collective consciousness. Some very recent newspaper reports have suggested that SARS hasn't been eradicated from the world, and I understand that in Asia, healthcare officials, as we sit here on this gray afternoon, are still trying to determine whether they have identified a fresh case of the disease. Happily, we can leave that debate, at least for this afternoon, to the microbiologists. And get on to what I'm supposed to be chatting with you people about, which I think is to try to bring some focus to the question of what businesses should be doing in advance to prepare for crises generally, whether it's another medical emergency, whether it's some sort of a chemical spill, whether it's some sort of a terrorist attack, which at some point in time we'll probably have, whether it's another power blackout, whether it's an ice storm, or whether it's anything in between. And because I'm a labor and employment lawyer, my comments will be largely tilted towards employment law issues. Having said all of that by way of introduction, if you're running a business or if you're giving advice to someone who does run a business, I respectfully suggest that it's about as irresponsible not to plan for unforeseen crises as it is for your business or your client not to have general liability insurance in place. And rather than debating what seems to be, at least to me, a self-evident notion, let me move on to some of the things that I think businesses should be doing from a planning point of view. You'll find in the materials what I truly think is an excellent paper. Let me say publicly that I had little to do with its excellence. Rather, the lion's share of the work and the writing was done by our brilliant articling student, Jeremy Hahn, who actually is in the audience trying to look inconspicuous. And when it comes time to hire back lawyers from all you guys keep your hands off of Jeremy, he's ours. The paper, I think, will take you through, in a very organized fashion, the major areas where businesses should have plans in place for the next crisis, because of course it's just a matter of time before that next one occurs. And so what I'd like to do in the fairly short period of time I've got with you today is hit the highlights. And so maybe we can try to have a little bit of fun
Although the concept of fun and talking about employment policies, I appreciate, might appear to some to be somewhat oxymoronic, but I want to chat a bit about employee policies. I want to talk about contracts with third parties, and the part that perhaps will be a little bit of fun will be all of these, what I think are illusory in the main, privacy concerns that seemed to come up when everyone was scrambling to figure out what SARS was all about, and privacy concerns that people seem to think come up in workplace crises. And my pitch today is a lot of those concerns are simply nonsensical. Okay, on to the employment policies piece of the comments. During the outbreak, we all know that there was some significant confusion and potential for significant trouble around areas like who should be sent home, who shouldn't be sent home, should someone be paid if they're sent home during a workplace crisis, what if somebody wants to go home but isn't really a piece of the crisis? In other words, what do we do? And I think, actually I don't think, I know, that an awful lot of this confusion can either be eliminated or certainly minimized an awful lot by having prepared in advance some fairly sensible, commonsensical, not unfair employment policies. And what I want to do to make the employment policies point is talk about this concept that we had pop up called clean sites. Now, of course, clean sites aren't places where we can inject illegal drugs. When we talk about clean sites within the context of workplace crises, what we're talking about is off-site locations where groups of employees are sequestered to work during the crisis. Now, why would companies do this? Well, if we go back to SARS, a lot of companies were very worried that if one of their employees either came down with the disease or if the medical health folks were concerned that one of the employees came down with the disease, the worry was that the whole workplace would be shut down. And I want to say it was a Hewlett-Packard plant. Barry, you've got a better memory than me. But whether it was Hewlett-Packard or Shorty's Bar and Delicatessen, the medical officer of health shut down a plant, I think for a couple of days, over a concern that one of the employees who people thought might have been infected with the disease had come into work and therefore put everyone else at risk, and we needed to put some parameters around it. And so companies very quickly came up with this concept of taking their employment force, splitting them into cells, if you will, and putting them into sites off the workplace. And that's a good idea, the thinking goes, because if someone gets infected with the disease, all you do is take out the cell rather than the entire workplace. And so during the SARS crisis, many banks and investment houses and the like, as examples, set up these clean sites, and you'll have all read in the press that employees largely voluntarily stepped up to the plate, agreed to work in these clean sites, and so everyone was happy. Well, let's assume that we have something not dissimilar that happens over the next several months. I don't think it's unreasonable to believe that this time around, employees will be just somewhat less sanguine about saying, okay, I'll put my life and my family's life on hold again, and I'll agree to go and spend 24 hours a day at the Best Western out on the airport strip. And so if we're going to give ourselves the ability to be able to establish things like clean sites in the event of future crises, and as I say, it doesn't have to be restricted to SARS, what is it as employers, because again, my bent, in addition to temporary insanity sometimes, is employment law. What do we need to do as employers to give ourselves the ability to do that if people aren't prepared to do it voluntarily? And I would have thought the answer is fairly simple. All you need to do is implement an employment policy within the context of the employment relationship that gives you the right to do just that. Because if you have an enforceable employment policy, using then as an acid test a wrongful dismissal claim or a dispute, my suggestion to you is that a court hearing this or a mediator trying to mediate it will say, if there is an enforceable policy to the employee, gee, I think we've got a bit of a problem. There seems to be an enforceable policy in place that permitted the employer to actually require you to do this in the event of a crisis. So please tell me why I shouldn't conclude that that policy is enforceable and therefore you haven't been treated improperly or constructively dismissed or whatever the claim should be. If we stop there for a moment, the question then becomes, okay, what do we need to do to maximize the chances that these kinds of policies will be enforceable? Because after all, these clean sites, you don't just go to the Crown Plaza for the day and then go home and go out for a beer with your friend and then have a drink with your spouse after you get the kids to bed, right? What you do, first of all, it ain't the Crown Plaza, okay? It is the Best Western out on the airport strip. And you don't get to go out for dinner, and you don't get to go down to the bar, and you don't get to go home and be with your family at the end of the day. You're there on a 24-hour per day basis. Otherwise, a clean site makes no sense, right? Why go to the expense, if you're the employer, of setting this thing up if you just say to the people at the end of the day, good job, now go on home and interact with the world. That's exactly what we don't want people doing. And so again, going back to our acid test of the wrongful dismissal claim, I would have thought, if our good friend and colleague, Mr. Kuretzky, was adjudicating this, what he would want is some comfort that the employer acted reasonably in implementing this policy. Why would he want that comfort? Because he's a comfortable fellow, but in addition, he's going to need to be satisfied that it was proper for the employer to say to that gentleman right there, I'm sorry, you're not going to be able to be with your family for the next X period of time, and by the way, we don't know what the X is. So what do we need in order to have an enforceable policy? First of all, the basic concepts of employment law will tell us that there's got to be reasonable advance notice that the policy is going to be implemented, right? And so I would have thought that reasonable in circumstances like these is going to be somewhat of a matter of months. And I guess with the flu season coming on, that suggests that we're probably going to have somewhat of a difficulty if all of our employment clients want to set clean sites up, but I digress. So in addition to requiring reasonable notice, I would have thought it would also make very good sense to give the people who are going to be affected by this policy some say in what it's going to look like. So let's get some employee input. Input doesn't mean the same thing as agreement, right? Judges understand that. If Barry was adjudicating this case, he would understand that we don't always have to have our employees agree. But what we do need to do is act in such a fashion that they got some input into what it is we're doing. What's the third thing we're going to have to do? We're going to have to make sure that we don't overreach when we apply the policy. So please, let's make sure that if we're going to use this policy, because it is a powerful tool, we don't do so before we've reached the conclusion that it's really necessary. If you follow those three fairly simple rules, whether or not the policy sets up a clean site or whether or not the policy does something else in your journey along preparing for workplace crises, again, the old acid test of the lawsuit, when you're in front of the adjudicator, rather than the adjudicator turning to you, the employer, because we're the dark side, and asking why it is we should be allowed to do what we've done to the employee, the adjudicator will say instead to the employee, wait a second, this had been implemented X months before, there was employee input, it seems to me that the employer was acting reasonably, I do appreciate that it's an impairment on your liberty, but tell me, what has the employer done about this that's unfair? And so that's going to apply, as I say, to whatever types of employment policies you want to implement. Now, let me talk a little bit about contracts with third parties, because it's not going to be very helpful for any of you if you get these clean work sites set up, if your service providers don't have to go with you to the clean site to be able to provide the services that you need to carry on business. And you saw this most compellingly, again, with the banks and the investment houses that set these clean sites up for trading floors. And so, of course, in addition to needing the people, they also needed the software, and they needed the whatever it is they also use when their traders go and trade in, whether it's stocks or securities or different currencies or what have you. So the suggestion here is make sure that you've got contractual clauses in your agreements with your outside service providers, so that if there is a problem, you don't have a big argument with them in getting them to come along with you. Now, the flip side of that coin is if you're obliged to provide something to your customers or your clients, then obviously make sure you've got clauses in your contracts that relieve you from liability if some sort of unforeseen crisis pops out of the woodwork and for whatever reason you can't deliver. Please don't rely on the traditional force majeure type of clause. When we were debating this around the office back in the spring, the conclusion that our litigators came up with, although I rarely understand what our litigators say, was that those force majeure clauses might not be all that helpful in the pinch, and I think the reason, I recall the reason was it had something to do with an act of God, and the theory was SARS isn't an act of God, and you know what, I mean, if you're going to have those problems in your lawsuit, I think it's time to find another lawsuit. So rather than worrying about common law doctrines that nobody seems to understand, least of all the litigation lawyers, let's be a little bit creative and draft some sensible clauses. I want to finish up, as I said I would, by trying to sort of debunk some of these privacy myths, because while SARS was going on, everyone was all upset about people's privacy rights. You know what? Everyone needs to take a little bit of a breath and calm down. Because the problems weren't near as bad as people thought they were. First of all, please keep in mind that come January 104, PIPEDA, and I can never remember what PIPEDA stands for, but it's the federal privacy legislation, right, is going to have about as much to do with employee privacy in the typical provincially regulated workplace as it has to do now, which is zippity-doo-dah, okay? And there are a couple of reasons for that. First of all, if the Federal Privacy Commissioner attempts to apply PIPEDA to provincially regulated workplaces on January 2004, at about 12:01 on January 2, there will be a constitutional challenge, and that constitutional challenge will be successful. It's been an awful long time since I was in law school, but last time I checked, property and civil rights are within the realm of the provinces, not the feds. So that's the first reason. Even if we do have valid privacy legislation in Ontario, and someday we will, you know, after the provincial government gets over the Oak Ridges moraine problem, wherever that is, and other crises of huge importance. I hope no one here lives on the Oak Ridge moraine. I think it's the idea is you're not supposed to. They will get around to privacy legislation. And when they get around to privacy legislation, you know what, folks? It's still not going to be a problem. And the reason it's not going to be a problem is because an adjudicator is not going to say to an employee who the employer had to question regarding whether she, he, or it had been in contact with whatever the triggers were back in SARS, you know, did you go to Guangdong province, right? Do you have a temperature of over, I don't know, whatever it was, and did you go to the Scarborough Grace Hospital? God help you if you did, right? I mean, an employee who says, I'm sorry, you can't ask me those questions is stupid, okay? If an employee says, I'm sorry, you're violating my privacy rights, send the employee home, and when she's prepared to have a chat with you about that, then we'll do it preferably over the telephone, right? She does not have a right to not answer those questions. And I mean, and there are all sorts of reasons why that's so, including the obligation by employers to provide safe and healthful workplaces for employees. On the other side, employees generally in the workplace, obviously, let's be sensible, don't have a right to pry into the personal affairs of other employees. Now, you know, if I work next door to Barry, who's about to tell me I'm 30 seconds over, and he's hacking away in his cubicle.
No, a minute.
Okay, and I know that Barry had been to some place where there was a concern about SARS. Then I have a right to go to my supervisor, Howard, and ask Howard to sit down and ask Barry whether he meets the criteria for being concerned about SARS. Right? And that's all I have a right to ask. I don't have a right to go prying beyond that into Barry's, you know, the way Barry dresses and where he buys his clothes. We don't want to go there. And so obviously, if we bring some common sense to bear, we will see, big surprise, that when we do have privacy legislation, it's not going to stop employees from asking legitimate questions that relate to their health, nor is it going to stop employers from eliciting that information about employees so that they can provide a safe and healthful workplace. I think my minute's up. Please do read the paper. It does a lot better job than I did of talking about the kinds of things that you should be doing for your clients to make sure that when the next crisis comes, they aren't scrambling and hoping for some altruism from employees and suppliers and customers and the like. Thank you.
Thanks, David. When I first met Constance Olsheski, which I did in 1972 or 1973, she was on a date with my roommate at the time. And we became friends as the months and years went on, and we decided one day we're going to practice together once we went to law school. Before that, it was just do business together, be in business together. And we have now for about 15 odd years. Now she's going to flip the table about some of the topics we're talking about and speak about suing your employees.
I have a whole background in history a lot more attractive than what Howard just described. And I feel, but anyway.
Not as relevant.
But not as relevant. I'll leave it at that. So when Peter asked His Honor Echlin a question, he said defense counsel, assuming, of course, that it's always the employer on the other side. Well, I'm here today to tell you about all those cases where it's the employee on the other side, and not surprisingly, with the evolution of employment law, those cases are becoming more often and more complicated, and various areas are being expanded, and that's what I'm here to talk to you about today. Now, I do have a paper, and I think it's found at tab 5, but I'm absolutely not going to be following it, so if you follow it, you and I are going to be at odds. I am going to give you an overview. Now, first of all, I'm going to talk about actions for poor performance. Now, in one case, Cole and Lockhart, this Cole owned an elk farm, and Lockhart was the farmhand, and one of the elk died. And Cole sued the farmhand because it was completely unacceptable that binder twine had been left in the hay, and regretfully this elk consumed it and died. So there was a lawsuit over this one, honestly. And the court found that this was a slight error. This was part of the risk inherent in running an elk farm. And consequently, the employee was not going to be held liable for that poor performance. That was in 1998. Fast forward to 2003, actually October, so just last month this was heard, a case Bank of Cathay and Chen in Vancouver. Now, Chen was this gentleman, bank manager of the Bank of Cathay, and they have about, I think it's 10 branches across Canada. They have just a few employees. He had actually 12 employees. Hate to tell you this, guys, but bank manager, 12 employees, he made $350,000 a year, honest. He had his MBA, and he had an authorization, I think a lending limit of about $8 million. And throughout the course of his employment, he honored some checks that were NSF. And of course, under the understanding, I guess this is typical in the bank industry, I certainly like my NSF checks to be honored. Hey guys, we have a relationship, I'm going to put the money in, honor the check. He also did some unauthorized transfers. He loaned some money, and I know that this is typical, having worked with some banks, where the security wasn't quite as tight as it should have been. So a new president comes in, wants to find out what's happening, asks for a report, and finds out that, the number of transactions is rather large, and the volume of those transactions is rather large, to the magnitude of $8 million of unsecured funds being honored when there are no checks. So he gets terminated, and the bank sues him for poor performance and for the damages that it suffered. And because some of those companies that the checks were honored went bankrupt as well. Sometimes checks came in, and before they were cleared, he had been paid out. So some of those companies went bankrupt. Anyway, the loss was $8 million. So the court heard this case a month ago and decided that Chen would be responsible for all of the bank's losses. There's an employee in Vancouver with a debt, court-established debt of $8 million. Now, how many banks out there are facing employees who do this very same thing? I mean, I know this exists. But what was probably the telling factor in this case is that he attempted to cover up for some of the big gaps in some people's account. So what he did is he transferred money from this account to this account, and then he transferred it back, and somehow, it all seems very complicated to me, but somehow on the books at some time it looked as if the bank wasn't really out of this money. But indeed, it was out of this money. So the court felt that this was dishonest behavior, a breach of the employment contract, it says, but dishonest behavior, and so it saddled Chen with an $8 million debt. Chen, there was no evidence that Chen benefited a penny from this. As a matter of fact, in his full cross-examination and his testimony, he always stated, and it wasn't to be disputed, it didn't say that he found him completely incredible, that he did it in the best interest of the bank, believing that the customers would repay it, giving the customers a little bit of extra time to get their business. Now, bottom line is, poor performance. We now have a case out there where employers appear to be able to sue employees for significant damages that they suffer. Now, I want to move on to fiduciary duties, because this is generally the area that used to get most of the coverage previously before poor performance came to the fore, as it just did. And we all know, even though law school is really far behind for some of us, Canaro and O'Malley somehow, sticks with us. Everyone remember Canaro and O'Malley? Anyway, the fiduciary duty. Well, recently, in 2000, there was a new case, Sanford, Evan, and Trezuzzi. And this was a case where Trezuzzi was in the selling of marketing lists. You know how you get inundated with this, will you contribute, because your name is probably on several of those lists. Anyway, this is the gal that was responsible, in part, that she was a broker list, or a list broker, and she would determine for a customer what list you want to buy. Let's hone that list to make sure that the list that you buy is absolutely the target market that you want. Anyway, she wanted more money, and the company wouldn't give her more money. So she went out and started her own business. And she took she started her own business, Competition. 2 employees went with her. In testimony, she said, first of all, Trezuzzi said, I never asked them to come. The employees say, she never asked us to come, we just followed her. And then competing business did significant loss to the original business. And of course, she was found to be a fiduciary and held responsible for the damages the company suffered, which was $200,000. But the interesting point of this case, and the way it shows evolution of who will be found to be a fiduciary, these other 2 employees one which was an office manager, far removed from the president, which she was, and another employee making $45,000 and $50,000 were found to be mere employees. And remember, that word mere seems to suggest you've escaped the fiduciary obligations. That wasn't the case. The court found that these two individuals who didn't hold a senior position, weren't in the policy making, were found to be fiduciaries, and they were found equally liable for the damages that the employer suffered by their moving over. Now, in another case in 2002, just last year, IT/Net and Berthiaume. This was a case in Ottawa, and supposedly the federal government gets its help by hiring a lot of independent contractors. This company, IT/Net, was providing the contractors to the Ministry of National Defense and International Trade. And so this one gentleman, Brown, who worked for IT, went in and developed a relationship with the top gun and then brought in Berthiaume to be the techie to do whatever it is that National Defense wanted him to do. He signed what is called a master agreement saying, Berthiaume signed an agreement saying, I will not compete for 12 months following this. And this relationship continued for about 2 or 3 years, and he was seconded to slightly different projects. And instead of the master agreement being redrafted, it was just an appendix. So they added an appendix saying, this is your new project. And in the appendix, it also said, and by the way, I acknowledge that I'm bound by this master agreement, which had this non-comp, non-solicitation clause. Well, the last time, he never signed it, because he said, I want more money, and I don't want to sign it. Anyway, they did continue with the contract. He got seconded. Brown, who was supposed to get it signed, went off on holidays. He said to his replacement during that period of time, make sure and get it signed. Berthiaume never signed it. So the 2-year period comes up. Berthiaume says, I'm going to go out and compete. I never signed it. Now, this was an independent contractor. Oh, by the way, when he did that, next day or a week later, he goes and he competes. So he goes into national defense through another company, but providing the same services he's been providing for 4 years. So the court, of course, IT/Net sues because it was their customer and an opportunity that Berthiaume, it felt, did not have the right. But how are they going to get him? He's not an employee. And he hadn't signed the contract. Now, whose responsibility was it to get that contract signed? Was it IT's responsibility to get it signed? Or was it Berthiaume's to say, by the way, I'm not signing the contract? And the court said, he's not a fiduciary, but we are going to hold him responsible for that contract whether or not he signed it. Because they said, the court said, he was dishonest. He should have gone up to them and said, by the way, I'm going to work there, but I'm not going to honor the master agreement. Now, to me, that's stretching it a little bit, but that's the way I believe that the courts are moving, and there was no fiduciary obligation here, but the courts found that this behavior, it called it, by the way, egregious, underhanded, and so when you've got a fact situation that causes such kind of comments to come from the court, rest assured that they're going to find a way, and in this instance, that's how they find it. They said that in his conduct, by continuing with the employment, he accepted the non-comp clause. Now, Soberman. Soberman was an employee who worked for KJA, which maintains elevators, and they were working on, by the way, the Commerce Court, a revamping of the Commerce Court elevators. Any of you use those, which was the second largest, supposedly, elevator project in Canada, if anyone wants to know that. Anyway, the owner of KJA suffered a heart attack, and he had a bypass, and he had complications. And at that vulnerable moment, Soberman says, by the way, as general manager, I want a $50,000 increase. And by the way, I want equity in the company. So, anyway, very fast forward. The company didn't honor it. Soberman went out, and the company said, sorry, we're not going to honor it. Okay, you can resign. He was going to resign. But the company said, please do this. Go, because it's a small company, not many companies, service elevators, says, take our new GM and introduce him to some of our senior customers. So he did. 1 month later, one of the customers of Commerce Court calls up Soberman, calls him up, and says, you're working on it. Would you continue it under your new company? Soberman does. This is really important because this is an evolution in the law. The court said Soberman could not continue with that contract even if he had been solicited. He was solicited to do that. He was honoring his contract by doing the introductions. He did not do it, and he was found to have breached his fiduciary duties. Now, I'm going to talk about damages. So I've talked about new causes of action, which is for poor performance. I've quickly gone over fiduciary duties and how they're being expanded, and even if you're not found to be a fiduciary, courts are going to find it if the conduct is considered to be dishonest or fraudulent or unattractive or unfair. I just want to tell you now about damages and how damages are now being enlarged. So punitive damages were recently introduced, and employers get hit with it occasionally. And the courts have now enlarged it so that employees are hit with punitive damages. So going back to Berthiaume. Remember Berthiaume? You know what? I've got 30 seconds.
Go ahead.
Yeah. Berthiaume, remember, he's the one. Anyway, Berthiaume got hit with $2,000 punitive damages. That's bottom line. You can now get punitive damages. 1 month ago, Chen, remember the poor guy who's doing everything in the best interest of the bank, and now he's got an $8 million debt? In addition to that, the BC court hit him with $100,000 punitive damages because of these, internal electronic transfers where he tried to make it look as if somehow there was money in the account. So punitive damages, I would suggest, have been thrown wide open, and there you go. Thank you.
Thank you very much, Constance. It's my pleasure to introduce Malcolm MacKillop. Malcolm, as you probably know, is the head of the Employment and Labor Group at Fraser Milner Casgrain across the country. He practiced law with Mr. Justice Echlin for a number of years, and they did a joint column in the Globe and Mail for many, many years. I think you're still doing that, Malcolm? Without Mr. Justice Echlin, no doubt. But he's going to deal with that very complex topic, is there still just cause? What happened to your trial, Malcolm? What happened to the trial? Your trial? Oh.
Yeah. Good afternoon. I would have powdered my nose a bit longer if I would have known the screen would be that big, but don't look too closely. How many people here have done just cause litigation, either, first of all, on the plaintiff side? How many people have done plaintiff side? You never know you're going to get paid or not, eh? On the plaintiff side, which is a bit of a problem. I'm in the middle of one now, and we'll talk about that briefly. How many people have done defense work on the cause side? Doesn't matter if you win or lose, you get paid, right? So that's good. The challenge in terms of doing just cause litigation, I think, has substantially increased, whether you are on the plaintiff side or the defense side. And I think I'll go through this with you, but my general feeling is that it has become somewhat more difficult for defense counsel Because when your client asks you that question, you know, so are we going to win, or give me the percentage chance that we're going to win, or do you really think that we've got a hope of winning this case? And the best you can probably do is maybe say, well, I think so. You've got a 50-50 chance. And then they ask you how much it's going to cost to do the litigation. And my assessment is that after the McKinley case, there are very, very few instances where you are alleging misconduct that you can have any degree of certainty. And although the McKinley case primarily deals with dishonesty, the level of disclosure required by an employee, it appears that the McKinley approach, the contextual approach, has been applied to any case involving misconduct. Most of you will know the facts of McKinley, so I won't go through them in detail, but essentially the case was about an employee who was on disability who failed to disclose his ability to come back to work with some medication. Essentially, the position taken by the employer is that this lack of disclosure, the lack of honesty in terms of fitness to return to work, was cause for dismissal. And interestingly enough, it was raised after the trial started, which is all bad, right? It's generally not the time to do that, as most of you realize. The McKinley case ended up with really a decision as to how you should examine dishonest behavior. And either you take the position that any form of dishonesty is cause, which traditionally most of us probably would agree that has been traditionally the thinking and the approach. McKinley stands for the proposition that in every case of dishonesty, you have to apply a contextual approach, i.e., the context of the act must be taken into consideration when assessing whether or not there are grounds to dismiss an employee for cause. What that requires the court to do is to assess all the factors surrounding the employee's dismissal, including the length of service, the duties, the effect that the misconduct had on the relationship, and also assessing the work environment in which the act occurred. In every case of dishonesty, as you know, you've got to prove that there was a dishonest act. And then the second part of this test is going to be determining the nature and degree of dishonesty. So what this really means is that even though you can prove dishonesty in this contextual approach, it's not going to win the case for you. In my mind, there are still cases that you can win. And the question really, if you're talking about financial misconduct, the question really is how serious of the fraud you're talking about, how serious is a misappropriation of funds. And I think it's safe to say after McKinley that a minor form of dishonesty will unlikely be cause for termination. Let me tell you about a case that I'm dealing with, and I'd love to have some feedback. I'm representing a plaintiff. We're going to go to trial in January. The plaintiff has 12 years of service, and he was a general manager of a private club. No discipline. Everybody would say he did a great job during his 12 years of service. One of his employees quit. 8 months later, comes back to the club and asks to have a private meeting with a couple of the board of directors, members of the board of directors, which they do. And following that meeting, the directors go back to the full board and suggest that there should be a termination. The recommendation is accepted, and they go and terminate his employment. They give him a letter that says, we don't like your management style anymore, and although we think there's cause to terminate, we would prefer to work this out. And we'll continue your salary in the interim, and we hopefully will be able to negotiate an agreement. They end up continuing his salary for 2 months. He retains counsel. They retain their auditor to go do an investigation. And they come back with a number of items. There's some stuff that deals with inappropriate behavior towards employees, both of a sexual nature and a non-sexual nature, dating back 8 years. No complaints during those 8 years, no any indication from any employees that they had a problem. But more importantly, there was allegations that there was some financial dishonesty. Here's where it gets a little tricky. The first incident is that he got a salary increase of $8,000 for the upcoming year. And this was in January. He went to the payroll clerk and asked for 2 checks be cut, $4,000 each, for a total of $8,000 without deductions. It was recorded in the books. Now, the interesting thing that you may be asking yourself is, why did he ask for 2 checks of $4,000 instead of 1 check for $8,000?
Approval process, right?
The approval process. Don't make up your mind too quickly, Howard. Just have an open mind to this. But the question makes me nervous. So,
And that it should.
as it should. Apparently, if you have a check for over $6,000, you have to get a director to sign. Now, his response to that is that, well, my son was getting married, I needed money, and the directors were all off in Florida. It would have been very difficult to do this. This was back in 1996. And I would have asked if somebody was around, but nobody was around. And so I simply instructed the payroll clerk to do this, and that's how I got my checks. The next thing is a clothing allowance. And he says he went and asked the employer for a clothing allowance of $2,000. He makes $129,000 a year and asks for an additional $2,000. The employer says no. Then he asks the employer, well, how about if I reduce my salary to $127,000 and then I'll get $2,000 as a clothing allowance, and it all adds up to the same thing. Now, you're probably thinking this is totally illogical, but that's his story. So he says they were okay with that. He goes back to the payroll person and says, will you deduct whatever you need to deduct on a prorated basis throughout the year to cover off this $2,000? Now, it should be fairly simple to substantiate his position if you just look at the payroll records, right? You'd look and see, well, did his income drop from 129 to 127, and is there an allowance being taken into consideration in his whole compensation? Well, if you look at the payroll records, you can't determine really that that actually happened. And I know you're doubting this at this point. However, he says that I can tell you honestly, Malcolm, that I told my payroll clerk to do this, and this would add up to maybe $65, $75, well, probably a little more than that, but $125 or more every month. And I don't look at my pay stubs that carefully. So I just assumed it was done. So this is really the facts upon which I think the case will be won or lost. Now, how many people here would say that in light of the fact that he had 12 years of impeccable service, and he was given 5, no less than 5 reference letters by board members at large about how great he was and how incredible job he did in terms of changing the club around over 12 years. And those reference letters came after he was terminated and after it was disclosed that there was litigation. How many people would think that there is sufficient dishonesty to warrant cause? One person? Well, is there? The question is whether or not it's sufficient misconduct to justify. Forget if he's believed. Let's assume that there's dishonesty here, because I think there's a real problem in terms of cutting 2 checks. It's not the amount. I mean, it's not a loan. It was his money, but the fact that he gets the benefit of having no deductions in the short term, the fact that he cut 2 checks makes it seem that it's clearly deceptive, right? He's trying to go under the radar screen so he doesn't need the approval. So how many people think that there's cause? This is very good. This is the best response I've had in about a month and a half. I've asked this everywhere I go in the last 2 months. I stopped bus drivers, I stopped cab drivers. I had this guy recently that didn't speak English that well and didn't understand.
You're going to disqualify half the city, then Malcolm, from the jury.
Yeah, but he nodded through the whole thing of my story, and I felt so good after that 20-minute cab ride. But the important thing here, I think, is that I have a concern about the clothing allowance. If you can't, it's illogical that you would, first of all, ask to have it divvied up like that, 127 and 2,000 p. You're still going to be taxed on it. And his response is that, well, it just made it, easier for me to know that I'd have $2,000 worth of clothing allowance every year. It's illogical. So let's assume that there's dishonesty. There's bad bookkeeping and at best dishonesty. So the rest of you that didn't put up your hand, I assume that you think I'm going to win this case. And I
Ask the
assume,
question again, Malcolm.
Just a shy bunch.
Ask the question again, Malcolm.
how many people think I'm going to win this case? The payroll clerk is a bit of a problem. That's a good question. Thank God counsel on the other side isn't going to be as smart as you. But
Did he tell you Mr. Mulrooney was going to be a special guest here? Mr. Mulrooney's the opposing counsel.
The payroll clerk is a bit of a problem. She is going to say, I think, that the request was made in terms of a clothing allowance. But that's all I know. And it's difficult to get a straight story on that. Now, in my mind, this is a classic case of McKinley, right? It's a classic case. I'm going to talk to you about a couple of cases before I sit down, but this is a classic case because you have somebody with a clean record for 12 years, impeccable performance, did great things, people are going to sing his praises. But he does 2 really stupid things, right? Cutting that check the way he did it is problematic. And asking for a clothing allowance and not getting it, again, is problematic if he can't show there was actually a deduction. So you would assume that there's some responsibility of a general manager who plays the role of a CEO in a small organization to make sure that if you're going to do it that way, the deductions are actually taken. But I think if you apply McKinley properly, you will look and you will come to the conclusion, yes, it was dishonest, but in light of the fact, 3 minutes. In light of the fact that you have somebody that had good performance, and this is all after acquired cause, then how much weight should it be given? What were the reasons at the time of termination? And I think if you look at a case in your materials called Black, it's a 2002 decision of the Ontario Court. I think this is very similar. You've got an accountant who has 13 years service, financial accountant, has sole signing authority over the checking accounts. The allegation here was that between the years 1996 and 2000, she gave herself and another employee unauthorized increases in salary and vacation pay. A number of salary increases. We're not talking one. We're not talking money that was already given to her and her employee. These are unauthorized salary increases. It was the court found that it was very odd that the employee did not ask the owner for the raise because her office was next door. Saw him, right? Why didn't she just go in and ask for the raise? She could have done that. Not like my guy, who he can't find a director who's all the directors are off in Florida, right? Very important fact. And then you have, in this case, a black case, the employee admitting that the owner was not fond of giving raises and was actually very frugal about it. We know this private club got more money floating around, so if he would have asked for the money, he probably would have gotten it, in my case. And in a black case, we have found as a fact that the owner refused the employee's request for an increase in 1995. So she asked for it, it's refused, and then she just starts taking it for 4 years. Much different than my case. The employee's explanations for the raises were suspicious, the court says. Well, I guess. The court's finding that the employee was not dismissed solely on the ground that she unilaterally increased her pay without proper authority. The owner had discussed her dismissal before he even knew about the numerous salary increases. Very much like my case, right? Very much like it. Now, the facts suggested that the company was using the unauthorized salary increases merely as a way to justify dismissal without notice. The court again recognized the fact, the uneven bargaining power between the parties, and said although the conduct was inappropriate, the alleged dishonesty did not give rise to the breakdown in the employment relationship. Now, could there be a better case for me out there? Right? Several incidences.
Malcolm, work on your retainer.
Yeah, I think this is good. Deliberately. But good question. I think there was no mention of the clothing allowance, and there was no mention of the 2 checks. I think most of the conduct and they refused to tell us on discovery what actually was told to them, which I find bizarre. But in any event, I think it had a lot to do with the improper conduct towards employees and the fact that he might have been seen taking a steak or 2 out the back door instead of eating. I didn't mention that because I think that's just superfluous stuff that's really not important. But anyway. Yeah. But however, I appreciate your feedback on this, and the reason I chose to talk to you about this case because I think it is a classic McKinley type of case. And I think that most people would be on the fence in terms of this case because the reason primarily being he had 12 years of good service and the unfairness involved in not doing an investigation before you terminate.
Malcolm,
right?
take your vote now.
The vote?
Take your vote.
One more vote, Malcolm.
Who thinks it's cause? Who thinks it's not cause?
How many people think there's cause? How many people think there's no cause? All right. Thank you very much.
Malcolm, we're doing a return engagement on the senior practitioners panel. We can try again on the vote. If you have any questions for the senior practitioners panel, if you just leave them in the box, that's great. If not, if we can be prompt on the coffee break, that'd be great.